probably in the back too. We'll probably fill it out. Is there something you're worried about?
No, I didn't, just mind my PPP until I get out from behind.
Yeah, no, I agree with you on that. Alright, so we are in the record in State of Nevada versus Raymond Tyrone Davis, C342946. Ms. Collins is here on behalf of the state. Mr. Davis is here representing himself pro per. Standby counsel, Mr. Klaus, Justice Klaus, is also present. So I just wanted to talk a little bit about how the jury selection process goes. So I will start out by asking just some general questions, and then as soon as I am done, then we're gonna go meet and confer in the back about challenges. We're gonna meet and confer up at the bench about challenges for people who are gonna go out of town, who are full-time students, blah, blah, blah. So generally, Mr. Davis, just so you know, people who can prove to me that they're going to be out of town, I generally excuse. People who are full-time students that are going to miss like a week and a half of school, I generally excuse. And then after that, we'll go into just asking our questions of those people in the box. And after I'm done, Ms. Collins will have an opportunity to ask the jurors questions. And then, Mr. Davis, you'll have an opportunity to ask the jurors questions. All right?
Yes.
So, how I like to do challenges for cause, I like you to just notate it like on your folder, and then when we go for a recess, or if like there's a break in conduct, say, Judge, can I approach, the state has a motion or defense has a motion?
Yes, ma'am.
Because I don't, so Mr. Davis, I need you to hear me because this is all important. I'm really doing this for your edification because Ms. Collins already knows how to pick a jury. So if you want to challenge a juror because you don't think that they can be fair, you don't just do it in front of the jury. You say, can we please approach, and we'll deal with it, okay?
Right.
But don't do it because if that person doesn't end up getting excused, you don't want them to know that you wanted them gone. You know what I mean? So after both sides have had the opportunity to ask the questions of the prospective jury panel, then you'll do your peremptory challenges. Because this is a life case, you get 9. Each side gets 9. The alternates will be jurors sitting in seat 13 and 14. So those will be the alternates, all right? So what will happen is my marshal will have a piece of paper, and you guys are going to pass it back and forth, stating this is my first peremptory challenge, this is my second, third, fourth, and you get 9 of those.
No.
And that's not till the end, though, after we've asked all of the questions. So the questions that I ask, I'll do those first. And waiver of 1 is not waiver of all. And you can use your 9. The last kick has to be for the alternates, though. Does anyone have any questions in regards to selecting a jury?
Just your own edification. I have this friend of the
Of course, yeah.
Edification, as you're going through the 4 cause challenges done first, then before you do the peremptory challenges.
Yeah, so let's say like we're in the middle and it starts becoming really apparent, you know, that juror number 9 is not going to be able to be fair. I don't like to just be like, Judge, can we approach, like right then, because I think it gives an indication to every other juror what you have to say, what you can say. So when you see a break in the conduct, like just maybe you move on to the next juror, just write down who you want to challenge for cause. Or write you, Mr. Davis, you write down who you want to challenge for cause. And then we'll deal with it up at the bench.
And do you want him to examine the jurors one at a time, Your Honor, or is it?
No, so what I do is I ask general questions, and if you guys need to do any follow-up on my questions, and then I ask you guys to do general questions. If there's follow-up, like if a juror asks answers a question, you want to do follow-up with them, that's totally fine. But we're not going to go like, Juror 1, ask questions. Juror 2, ask questions. No, we're gonna do it at full. Let's see, what else?
Does your honor ask the ever been a victim, ever been accused questions?
Yes.
Thank you. Thank you, sir.
All right. Thank you. So, Mr. Davis, in regards to how is the house arrest bracelet issue going right now?
Well, it won't charge, I gotta wear it here. I mean, I gotta keep it plugged up most of the time, so.
Okay.
I got a couple of motions,
Okay, well, right now we're gonna deal with this. So, I told you yesterday that I would absolutely order house arrest to provide you with a new bracelet, so that you wouldn't have to charge it, in court, but you stated that you did not want to go down to house arrest, is that right?
they're mean, they're very mean people, I don't want to.
Okay, the question was, your answer to me was you are not going to go down there and get the new anklet.
They got a new one?
I told you yesterday, you could go down there and you could get it switched to another ankle and get a new one that would not need to be upcharged every 15 minutes, and you told me that you weren't going back down there because they were rude to you, right?
Yes, very rude.
Okay, so you realize right now, you have chosen to wear those sweatpants again to court that show, do you have your sweatpants pulled over the bracelet?
No, and I want the jury to see it. I want the jury to see this.
Okay, so
Yeah, I got a motion, it's gonna be part of my, one of my motions.
okay,
Because I looked it up all over, no defendant has ever went to court with an ankle bracelet.
now
So-
that's,
Well, I couldn't find anything that a defendant went to court with. He stood up himself, and he done did hundreds of cases and said he'd never seen it before.
okay.
So, to violate my constitutional right to a fair trial by making me wear an ankle
You
bracelet to
realize,
trial, my Sixth Amendment
okay,
right.
well, my turn. You realize that inmates from the Clark County Detention Center stay in custody during trials, right? And then come in here dressed in suits and normal clothes and still aren't having the issues that you're having. I offered to have you go down to the house arrest office to get it, because you complain that it bruises your ankle. So to get a new one that doesn't bruise your ankle, to put it on a different foot, and to have a new one so you didn't have to charge it. And you have refused every item of help that I have offered you. You recognize that, right?
I don't recognize that being help, that I gotta go be in trial and I gotta go to the house arrest people every day, twice a day, to, get my new ankle bracelet or
Twice
whatever
a
you
day?
told
What are
me
you
to do.
talking about? I didn't say you had to go twice a day.
So, I got a couple of motions I wanna put in before the juries.
Okay, well, what are the motions? Because like I said, you don't get to just file motions. I
Okay,
mean,
first, go ahead.
you don't,
I apologize.
you can't just come in here every day and file new motions. I mean, there are there are procedures that must be followed. You file a motion, and then the state has an opportunity to respond in writing, and then you have an opportunity to respond in writing, and then I hear them. But you coming in every single day with motions is not how this is going to work. What is it that you feel needs to be addressed?
Well, the ankle bracelet, first of all. I got a motion to remove this ankle bracelet. Court has violated my Sixth Amendment rights by forcing the defendant to wear an ankle bracelet during trial. I have been denied my right to a fair trial, which is a right protected by the Sixth Amendment right. The defendant asked the court to remove the bracelet for the trial. It was denied. The judge asked standby attorney, has he ever seen a defendant in court with an ankle bracelet? His reply was no. If a jury sees a defendant in an ankle bracelet, it will persuade his case furthermore, prejudice his case. The ankle monitor, due to balkiness, blinking lights, and everything, cannot be hidden under clothes like the judge told me to hide it under clothes. Plus, the bracelet needs to be charged up. I asked the court to remove the ankle bracelet. During trial, they refused. He got the lowest, the defendant got the lowest possible score for pre-trial assessment. He has no flight risk. He has a bail. What is bail for if bail is not used? And then they put you in a program where you got to sit in court like a dummy with an ankle bracelet on that's been on for 5 months. And then I put that's my motion, I put the ankle bracelet there that you have, and I put my pretrial assessment.
Ms. Collins, your response?
Well, Your Honor, we've given him options. He just told you that he wanted the jury to see the ankle bracelet. I guess that's in some sort of effort to engender sympathy. There's very few sex offenders who are charged with these kind of offenses are walking around out of custody. It's very unusual. So, we gave him options. He could have wore dress slacks to court today. He could have gone to the house arrest office. Honestly, to me, the option is you want to go in custody, then you can wear a suit and no ankle bracelet, right? There's no prejudice to him if he's saying he wants the jury to see it. He's making the choice right now. I think what he's trying to do right now is kind of bully the court into removing it. He has substantial ties to California. I think if you take it off, he's gonna run. That's what I think.
All right, so the defendant's motion can be filed. Marshall O'Kelly, would you please grab that from Mr. Davis? It'll be marked. I understood. Thank you. That motion is denied. I previously addressed all of these issues. I've given the defendant every opportunity that I could think of under this scenario. He chose to wear the same outfit he was in yesterday, including a pair of gray sweatpants that he not only refuses to put his sweatpants over his house arrest bracelet, he in fact tucks his pants under his house arrest bracelet. So he also placed on the record that he wants the jury to see his house arrest bracelet. So that motion is denied. Next.
Okay. I don't need this one anymore. This one's no good. Most of them you just answered. I respect the move to ask that this case be dismissed due to a lack of evidence, no physical evidence.
All right, so we've already talked about this. Sufficiency of evidence, lack of evidence. I know that you know this, so you tell me, what is the vehicle I have told you that you may file that with?
The writ.
A petition for writ of
Writ.
habeas corpus.
Okay, so I don't need that.
That's denied.
Okay,
Are you taking it off calendar, or you want it marked?
I want it marked.
Okay, Marshall O'Kelly, could you please have that marked? The entirety of that document, much like the document yesterday, is sufficiency of the evidence, which I've explained to the defendant. I am happy to look at the sufficiency of the evidence in this case, but it must be done by filing a petition for writ of habeas corpus. He's refusing to do that. He wishes his trial to start today. That motion is denied. Next.
I want a motion to dismiss the defect in the charging documents. In the state's charging papers, there is no dates. There is no dates. It's just generally a year. Here. There's not one date of this happened to me on this date. Unlike the case yesterday where the girls that came to trial had dates.
So you're saying failure to plead with specificity in regards to the date ranges?
Yes, Your Honor.
Ms. Collins.
Your Honor, that's also a writ issue, as this court well knows, that's had to be addressed in a writ of habeas corpus. And the court well knows that time is, the state is not required to prove a specific date, but only a frame of time when it comes to sexual abuse charges.
So Ms. Collins is right in regards to both, really. So that is a sufficiency of the evidence that would need to be dealt with by petition for writ of habeas corpus. But just so you know, there's been a lot of case law in regards to sexual assault crimes or child abuse crimes in regards to basically crimes against children and them being able to remember specific dates. And so the case law does talk about the prosecutor can plead a larger date range as long as the victim can say that the conduct happened within that date frame and can give specific instances. So that motion is denied.
Your Honor, yesterday you did bad acts with her, the bad acts thing. I would like to challenge that and not be allowed. Because the simple fact is, this is a whole different case. This is a case where the girl said that she gave oral sex at
So
13.
are these different than your arguments made yesterday? Because what happens is if you wish for me to reconsider, you need to file a motion for reconsideration that shows there are new facts or that I was clearly erroneous. So if you're not, those are the two ways that I would need to be able to hear for a motion for reconsideration.
This is a motion for reconsideration.
Okay, based on either new facts or clearly erroneous.
Well, I'm trying to get to the relevancy of that.
Okay, then you can file a motion for reconsideration for two reasons. That I was clearly erroneous, or that there are new facts that you need to present to the court. Do you have new facts to present to the court?
Yes.
And what are those?
I have facts that she was not at no time 13 when she said she was 13. Nunez.
Erica Munoz?
Mm-hmm.
Your Honor, she said she was 15.
No, yesterday she said she was 13.
Okay. Alright, so I'm sorry, but, okay, so that's the new fact, is that her age?
Yes, I'm questioning her age because she got on the stand and said she was 13, and what's relevant about that is this Vanessa Robinson victim is 13, so that's category around in the same thing, and this is showing a pattern of how this prosecutor likes to back people's age up and make them younger than what they are. She did it to Mrs. Nunez yesterday. She did it to...
Is there Ms. Nunez? Am I getting this wrong? Isn't it Erica Munoz, or who are we talking about?
Munoz, I don't know how to pronounce her name, whatever her name is, the girl that testified
Okay,
yesterday.
Erica Munoz.
But
M-U-N-O-Z.
I can't pronounce it, so I can just call her Erica.
Just call her Erica.
Okay, Erica. So, the prosecutor has shown in order to bring these charges up, she had to back Vanessa Robinson's age up. She did it again yesterday by backing this girl up, that this girl had her testify that she was 13, when, in fact, when she gave her birthday and everything, it proved that she was 15. But the DA knew she was 15. But to tell alleged victims to back up your age, so, okay, the difference, Your Honor, between a crime against a 13-year-old and a 14-year-old is humongous, humongous. So I can prove beyond a reasonable doubt that there's no way possible that I could have met Vanessa when she was 13.
But Vanessa is the victim in this case.
Right,
I know. So
I'm
this
saying,
is about the motion for bad acts.
right, so now, when she gets her on the stand yesterday and have her say that she's 13, that's a huge flaw, because you allow the bad acts in because of the similarity of age. 13, she says she's 13, Vanessa says she's 13.
Okay, but that's not a new fact from yesterday. You gotta stick to the rules. You gotta present me with new facts.
Okay. So, it's not a fact that she's 15, it was a fact that she was 13 yesterday.
Yeah, but you brought out that she wasn't that age yesterday, right?
No, it wasn't brought out by me.
I thought that you even cross-examined her on that aspect.
No, you can get the transcripts. It was never proven by me that I never asked her because I didn't realize it until I got home.
Okay, so your motion for reconsideration is based on the fact that Erica was actually 15 and not 13.
Yes, Your Honor.
Okay, but you realize that that would be closer to the age of Vanessa, correct?
Yes, Your Honor, but part of your, well, I can't go into your thinking, but you would think that when someone says 13, if somebody says 13, Your Honor, you're more pissed about somebody that would say they're 15. I mean, 15 is a whole different level than somebody that's 13 because it's a different crime. I mean, it's a different sentence. You say 14 and under. This is why this is why the prosecutor kept hammering the 13. She wants everybody on the planet. She wants every girl on the planet to be 13. Because this gives the state more chance to hammer me.
Okay.
May
Ms.
I,
Collins, go ahead,
So
please.
I did misspeak just a moment ago. So I did make a record yesterday that the occurrence of this event was June 27th of 2004,
Right,
and that her date of birth was 8/13 of 89,
right.
which made her 14, turning 15 the following August. So I did misspeak. I don't know why she said she was 13. This whole suggestion that I've, pushed back ages to try to suggest some more relevance to the court is absolutely ludicrous. But so there is in the record that she was 14 based on the date of the occurrence of the 2004 case and her date of birth.
Alright, so the motion for reconsideration is denied. I don't find that any of my findings were clearly erroneous, nor am I shown facts that I feel would raise to the level for me to reconsider my previous ruling. Next motion, please.
Your Honor, also, if she misspoke in this one by backing up this girl's age, maybe it was a mistake. I'm not questioning that if it was a mistake. Maybe she made a mistake in the charging documents with Vanessa by saying Vanessa was 13 when she was actually 14.
Okay, but if she made that mistake, then I'm sure she will let us know and make a correction.
Well, if she made a correction, Your Honor, all the charges would be different.
Right.
Right, okay.
So if she needs to correct anything, I'm sure that she will.
You better get to correct it.
So what we're not gonna do is we're not gonna have comments like that to Ms. Collins. If you have a comment, say it to me.
Well, I just said that some things need to be corrected.
No, I heard what you said. Don't play games with me because it's not gonna go well for you.
Okay. Your Honor, I'm asking for a change of venue. The fact that the familiarity of this prosecutor with Your Honor, that possibly you guys...
That's not a change of venue.
Right.
That's a motion for
Right.
recusal.
No, I'm not asking for a motion for recusal. I mean, you're free, I can't tell you where not to go, where to go. I would never do that. I would never tell anybody that. I'm asking for a change of venue because I feel that my chances of a fair trial in this courthouse, not your court,
Okay, just in any court in here.
any court here is jeopardized due to the fact that my photo was posted all over the internet because the courts allowed someone to come in here and photograph me.
Well, they didn't allow it. They didn't know what was going on. I mean, you can't say that the courts allowed it.
Well,
I can't keep track of every single human being in here. If you come in tomorrow morning at 9:30, you'll see every single chair is taken and people are standing. So don't say the courts allowed it. I'm sure Judge Kadish wasn't like, feel free to take a photo of Mr. Davis and post it to Facebook. I mean, I think there's even a sign out there that says no cameras.
well, okay, Your Honor, so even if it wasn't, it still hampers my ability to have a fair trial by somebody posting this, and especially when they're a witness to the state. So I think if this case is taken to North Vegas, to Henderson.
So the problem is all those cases come here. Those are justice courts.
Mhm.
So right here is the only district court in Las Vegas. All the cases from North Las Vegas and all the cases from Henderson and all the cases from Las Vegas come here to this courthouse. So change of venue would go somewhere like up to Reno.
Okay.
So I talked to you yesterday about there being safeguards in place. There are cases that are publicized times a billion from what you're talking about, and they're still tried within this courthouse. And we have certain safety procedures that are put in place where I will ask the jurors, have you heard anything about this case? Do you recognize anybody in this case? Do you recognize any witnesses? Do you recognize Mr. Davis? Do you recognize Ms. Collins? Do you recognize me? Have you ever seen anything about this on Facebook, Twitter, anything like that? People raise their hands and they say, yeah, I did, and then we'll get rid of them. As long as if they say, I read about this, I saw this, I can't be fair, then they're gone, because it's important for you to have a fair trial. We're gonna make sure that that happens. So the motion to change venue is denied. Marshall O'Kelly, can you please approach that?
I got a prosecutor misconduct.
We dealt with that yesterday.
No, I didn't file.
No, you did file prosecutorial misconduct
I did?
yesterday. What is the basis today?
Okay, it's the same one I did file yesterday.
So that's taken off.
Okay, I'm filing for pre-trial, dismissal due to pre-trial delay, and it's not the one where the docket from my first.
How is it different from docket?
Your Honor, when I was arrested was almost 5 months ago. When I was arraigned was almost 5 months ago. I never signed any waiver to waive my right to my 60-day. I looked it over plenty of times. They put me on calendar several times. They pushed it back. At no point in time did I say I wasn't ready. Several points in time, the state said they wasn't ready. So even with the docket, and I quote United States versus Elwin, 383 U.S. 116. That's my point of authorities. The delays have really hampered my ability to defend myself. My paid counsel was ready to go to trial. I had the financial means to pay them to go to trial as long as they want. But the simple fact that the court made me wait basically made my paid counsel ineffective because, I mean,
Wait, what?
well, it made my
Who's
defense.
making-
It made my defense ineffective because with the passage of time, more and more evidence of this case of my. So I had four witnesses come to Greg Mueller's office. 4 of them. They sat there. They gave their testimony, their statements to him. We sat in the meeting room, and we were ready to go. We were ready to go to trial. Next thing I know, the state is not ready. And
Oh, no. We're not gonna get this twisted. Your counsel filed a notice of alibi on the eve before trial. That has to be done within a certain period of time. Your defense necessitated a continuance.
No, not that one, Your Honor. You got the wrong one. It was before that. I'm not talking about the alibi.
Okay, hold on. Your information was filed on May 13th of 2019. So now, I'm looking to see when your first trial was set.
Your Honor, his first trial was set July 8th. I was out of the jurisdiction. Mr. Mueller didn't mind moving it a week. So I don't know if that's what he's referring to. There was Mr. Mueller had not filed a notice of witness. Mr. Mueller had not filed a notice of alibi. I just will have the court know that,
That's the day.
his prelim went forward on the first day that it was set, on May 6th. That was the bind over. They set the court date, the first trial date, shorter than 60 days. I had travel plans, I wasn't gonna be here. And we moved it to the 60-day date, which would have been the July.
Yeah,
The
no,
first July
July 22nd is his right to a trial within your right to a trial within 60 days, okay? Miss Collins was originally out of town the week before, so the court moved it to July 22nd. On that day is the day that Miss Collins represented. There were 10 witnesses, and I noted the receipt of the state's motion to continue based on the filing of a notice of alibi witness filed Friday at 4 p.m. by defense in violation of NRS 174.233. So that was your defense counsel not following the rules. That's the very first trial setting in July. So you had arraignment in May, you had your first calendar call in July, you were set to start trial on July 22nd. I remember we were all here, and you were upset, if you remember, because your counsel failed to file the alibi witness.
They filed it. They said it wasn't within 5 days. She put it on the technicality.
Well, that's the rule. It's not a technicality, it's a rule.
Okay,
It's
yeah.
actually not 5 days, I think it's closer to 15, and they have to give the substance of the alibi, so that not only was the notice late, it was qualitatively defective.
Your Honor, I came to court, I remember what day, I was dressed, came to court, I was ready for my trial, I had my witnesses in town. my defense was ready, we were ready for trial. Then I looked down there and I got very upset because I didn't see my name for trial. I called Greg Mueller,
Craig, his name is Craig.
Craig, whatever. I said, I'd like to, what's going on here? And he says, oh, I apologize, Your Honor. So I said, what's going on? And he says, well, there were some issues in the court and we had the trial moved. I says, why wouldn't I be told that?
But that's between you and Mr. Mueller. I have the record right here, July 29th. The alibi witness was filed late. Your choices were to go without those witnesses or continue it so you could have that as well as the docket hearing that was on that day. So that was done. Those were your choices. You stayed in invoked status. I got you on the very next setting. That's what we're here. So that motion is denied. Please mark it as an exhibit. I have a jury that's been out there for 40 minutes. Do you have anything else?
That's it.
Please bring them in.
I just need a couple of minutes, but I can't be over.
Is that a motion or exhibit?
Dean, we need to wait for a second because we gotta do some stuff up here. So would you just make sure they're in order to
I'll
be
just
thrown?
get lined up, yeah. You're on.
Yep, Your Honor, is that exhibit or motion?
How can we remedy that? Do we
Go
have
get,
to?
they need to go pick up the jury list well before we start, otherwise, as soon as you get on the bench, I have to take notes.
Okay, so remind me next time. So I just haven't known how it works. And I don't know.
No.
Okay,
But, so in the future, we'll have him go down earlier or have him send up something.
yes, much earlier before we start, then I can have it all prepared.
Got it. That's
But
easy.
I'm almost out, just need a
No
couple.
worries.
Your Honor, can you do one more question for you?
Yeah.
What day shall I be calling I gotta get all my witnesses from out of town here. What day will I be calling my first witness?
When is, Ms. Brown coming, did you say?
Monday afternoon.
So probably either, I would think Friday or Tuesday, if he takes them out of order, because are we just gonna be dark Friday, what are we gonna do?
Well, I didn't really set up a time schedule because I didn't know how long everything was gonna take, and we're gonna have 6 motions every time we walk into court. If we get a jury midway through tomorrow, I can probably have witnesses for most of Friday.
Alright, I'm thinking the beginning part of next week, but we're just gonna have to see how it goes the rest of the week. I don't know, cause I don't know, for instance, right now, we could have already been picking a jury. For 45 minutes, we've been sitting here arguing about
I'm
things.
sorry for wasting this.
That's okay, you're not wasting my time, but there are rules that need to be followed. So from now on, motions are going to be filed in open court. The copy is going to be given to Ms. Collins. She's gonna be given, 5 days to respond, or I'm gonna have to look in the statute for the specific amount of days, but we're not gonna do trial by ambush where the state just has to respond orally to every single motion you walk in here and file. So by the time we leave today, I'll have the statute pulled up in regards to the proper timeliness of motions, because normally, I believe all substantive motions are supposed to be filed 10 days previous to the trial. But I'll need to check on that, and right now I need to get this jury in here.
And Your Honor, I absolutely will accommodate if we need to call people out of order. I hadn't really thought that through.
Alright, let's just see where we're at.
What time would you like to start to?
Tomorrow, how many do we have on our,
It's fairly large, you know, we have the 11 o'clock our daily dinner.
we're not gonna be able to start till 1 tomorrow because I have an insurance hearing at 11.
Yes, thank you.
Your Honor,
It's fine.
that's fine with me.
Tomorrow, Your Honor.
What do you?
1 o'clock tomorrow, Your Honor.
Yes,
I can come anytime you want.
okay, thank you.
And Your Honor, I request one more thing from the court. I didn't want to put it in a motion or nothing, so, just keep flooding you with motions. I want to show you some kind of respect. I would like to get because the prosecutor has it, but I don't have it. The DA has it. Her juvenile record and her adult record in court. I would like to, for purposes of impeachment, I addressed that. I don't remember when I addressed that with you, but I did, and I have yet to get any.
Ms. Collins,
Your Honor, he actually brought that up with me in a conversation with my investigator. I explained to him that juvenile records are sealed. I also explained to him that because of the nature of the disclosure of this case when she was in juvenile detention, they're gonna know she was in juvenile detention. And because of where she reviewed the photo lineup, they're gonna know that she ultimately ended up in Caliente Youth Center. So he's not entitled to the substance of that. Those are sealed. That would have to be done in a motion and request to family court to have those unsealed. I don't have any adult criminal history for her now. She's just now 18, I think. She's in school, so I don't have an adult history. I will run her again. I will tell my investigator to run her again. Obviously, if there's anything that goes to her credibility or a felony conviction within 10, I think he's entitled to that. But her juvenile history is sealed, from my understanding. So that would have to be.
If you wish to unseal her juvenile record, you'll have to file the appropriate motion.
Right, that's what I was told, you know, today. The thing is, I think, I don't actually think they automatically seal juvenile records. I think it's a process you have to go through. So it could be possible that her juvenile record isn't sealed and that Mrs. Collins is assuming they're sealed. Also, the judge in this court has the power to unseal.
Right, and you need to file a motion. We're not doing this orally.
Okay, so I got.
File the appropriate motion, not just saying, I wanna unseal it. You need to have the case law that tells me what I can do. And I'm not even sure I have jurisdiction over this individual's juvenile records.
Your Honor, say her records are not sealed by some chance, that her records are not sealed.
So juvenile records are always, I think
Automatically sealed?
we're using the word sealed, but I mean, juvenile records are basically protected, I think is the right word.
Right.
So, and sealed is something that we use when we say, you know, let's say someone gets a DUI and then 10 years later they want it sealed and it's sealed. That's different than juvenile records. They're somewhat protected because it's a minor's records.
Right.
So if you wish to have the court determine whether or not you can get into those juvenile records, you'll need to file a motion with the applicable law that allows you to do that.
Yes, Your Honor, I'll be moving it to get her protected records in court. Everybody uses the word seal and everything, so I get caught up in using the word seal, but I know they're not sealed, they're just protected. I think with a case of this magnitude, I think it's very important to get her records.
Okay, so file the motion. All right, so while Keith is filling that out, would you bring them in and line them up, please?
Yes, Your
Thank you.
All rise for the entrance of the prospective jury. jury are present, Your Honor.
Okay, wonderful, thank you. We are on the record in C-340075, State of Nevada versus Raymond Davis. The record will reflect the presence of Mr. Davis with his standby counsel, Mr. House, the Deputy District Attorney, Ms. Collins, all other officers of the court. Do both parties stipulate to the presence of the jury on your panel?
Yes, Your Honor, thank you.
And do you stipulate to the presence of the panel, Mr. Davis?
Yes, Your Honor.
All right, and are the parties ready to proceed?
State is ready.
Ready.
Thank you. Oh, good afternoon, ladies and gentlemen. Welcome. You are in Department 6. I'm the presiding judge in this department. My name is Jacqueline Bluth. You've been called upon today to serve as a juror in a criminal case. There are a total of 9 charges in this case. Those include sexual assault with a minor under 14 years of age, open or gross lewdness, and lewdness with a child under the age of 14. We expect this trial to go into next week. Hopefully closing arguments would be around Tuesday or Wednesday. Our trials generally run from no earlier than 9:30, and I don't let the trials go past 5 o'clock in the evening. Ultimately, 14 of you will be moving forward to be selected as the actual jurors in this case. In this country, we place great faith in our citizens as jurors to reach fair and objective decisions. Part of what you're doing here is you're being good citizens of our country and our community. Jury duty is a civic responsibility like obeying laws, voting, and paying taxes. We appreciate the fact that you responded to the jury summons and showed up willing to do your job. It's important what you are doing here, and I firmly believe in this right that we all enjoy by being citizens of the United States. I hope that you enjoy your experience as a juror for those of you that are selected, and that you find it rewarding. Even with everything that I just said, I know that it is a hardship for many of you, and that it's inconvenient because you have jobs, you have families, you have all sorts of other things that you should be doing and that you need to be doing. So please don't think that I don't recognize that. I actually received my own jury summons a couple of weeks ago, so I get it. The issue is I want you to think of how you would feel if you were an individual involved in a trial, and how much you would want someone to be fair and reasonable and to believe that they needed to be here and be doing a good job. The other thing I want you to consider is that just because you may get out of this jury service, it doesn't necessarily mean that you get to leave the doors and go home. So let's say you bring up a reason why you shouldn't be serving on this jury, then you actually go down to jury services and they may put you into another jury panel in a different department. So while this may seem long to you, a week or a day over a week, there are some trials going on right now that actually last several months. So 6 days should be actually looking pretty decent when in comparison to some of our civil trials that are going on that are lasting several months. So let me take this opportunity to introduce my court staff to you. You've already met Marshall O'Kelly. His job is to maintain order and security in the courtroom. He's also my representative to the jury. Anything you need, any problems that you may have, any questions that you need asked, just see the marshal, and he'll make sure that those issues, questions, problems are brought to my attention. Please keep in mind, though, he cannot talk to you about anything regarding the case. To my far left is Deanna Takis. She is what's referred to as a court reporter. In the olden days, we used to have reporters, right? So there'd be an individual who'd sit in front of the judge and she'd report everything, and you'd see her clicking. That's not how it's done most of the time now. It's actually recording. So everything that we're doing here is being recorded. It will at a later time be typed out. While we're on the topic of everything being recorded, you will see that there are several cameras throughout the courtroom. What I want you to know, and it's very important to me that you know, is that jurors are never recorded. Your faces are never recorded. Those cameras are actually for security purposes. So if you're selected as a juror, it's not like there's going to be this recording of you or having conversations or anything like that. I know a lot of people really get a little bit nervous when they see those cameras. On my immediate left is Keith Reed. He is my court clerk. He He swears in the witnesses, marks exhibits, and keeps track of evidence and prepares minutes of the proceedings for the court record. Next to me is Shannon Reed. She is following Mr. Keith Reed. They are not related, but she is shadowing him because she's also going to be the court clerk. You may also see my law clerk, which is Miss Nicole Woody. She is a recent graduate of law school, and she's with me for a year. I'm lucky to have her. She helps me with researching the law, helping out with all things that I need help with. You'll also see my judicial executive assistant. Her name is Crystal Jacobs. She comes in and out throughout the process, handing me papers, things like that. But she makes sure everything's running smoothly in the back. So, what I'm going to do now is the state is going to stand up, introduce herself. She's going to give you a quick fact pattern of what is involved in this case. It's by no means an opening statement. She's just going to give you a little information so you can kind of understand where this case is going. And then she's going to read a list of witnesses. Please make sure you hear the names that she calls, because later I'll be asking you if you recognize any of those names. Ms. Collins.
Thank you. Good afternoon, ladies and gentlemen. On behalf of the Clark County DA's office, thank you for being here this afternoon. My name is Chief Deputy District Attorney Stacey Collins. I've been assigned to prosecute the case of the state of Nevada versus Raymond Davis here in Las Vegas, Clark County, between January of 2014 and July of 2015. Defendant is charged with sexual assault on a minor under the age of 14, lewdness with a minor under the age of 14, and open and gross lewdness. Those acts occurred in his apartment over in the area of Nellis. The named victims in the indictment are Vanessa Robinson and China Rowells. In addition to those people, those young women, the state may call, not all of these people, but some of them, Jeffrey Calzada, Haley Ferris, Erica Munoz, Ashley Heredia Perez, Las Vegas Metropolitan Police Department Detective Huth, Paul Martinez, Roxana Martinez, Las Vegas Metropolitan Police Detective Arturo Martinez, Cecilia O'Hare, Tyler Peterson, Las Vegas Metropolitan Police Department Officer Rolat, Carmen Roca, Isaiah Roca, Esther Rodriguez Brown, Detective, Las Vegas Metropolitan Police Detective Donnie Shane, Eric Story, Adriana Walker. If you recognize any of those people, or think that you may recognize any of them, please let the judge know, and she'll discuss it with you. Thank you.
Thank you. Mr. Davis, now would be the time for you to introduce yourself and give a list of any witnesses that you intend to call.
I'm Raymond Davis. I'm the defendant in this case. I no longer have paid counsel due to the fact that the state...
So you are, Mr. Davis is representing himself in this matter. He has standby counsel, Mr. Augustus Claus, who's sitting to Mr. Davis's right, which it's anyone's right in the United States to represent themselves if they so wish. Mr. Davis?
You guys know what Alexa is? That's what he is. He's basically my encyclopedia. He cannot help me in any way. I had paid counsel.
Mr. Davis, you have to list the witnesses. That's okay. That's all right.
It's okay. Phones are allowed.
Well, no, actually they're not. So you can have them on your person, but they have to be turned off. Don't worry about it. It happens all the time. It's no biggie.
If it's up to me, you guys can have your phone.
Mr. Davis.
So, what they did was the state basically, I'm on my own. So, I'm at my life. They have to take.
Approach.